All right, good evening. So we're going to talk today about evidence and objections in the trial advocacy sphere. Now, it's almost trite to say that objections annoy jurors, but it's true. Objections annoy jurors, and sidebar conferences to discuss objections annoy jurors. So in Massachusetts, we have a very strict rule of no post-trial contact between lawyers and jurors. It's a big problem if you do that, big ethical problem. But judges can do that. And every judge I know goes to talk to every jury that they ever have. And I would make an educated guess that every judge goes to talk to every jury that they ever have in a trial. And if you go and you talk to them and you thank them and things like that, there's a guaranteed way to get a big laugh out of jurors after you go to speak to them after the trial. And it's kind of a dumb joke, but I'm going to tell it to you anyways to tell you about the mindset of jurors. So let's say you go to speak to the jurors after the trial, you're the judge, and you're chit-chatting with them, thanking them for their service to the community, and maybe they ask a few questions when you're finishing up. Naturally, you want to answer people's questions as long as they're not about the case. And sometimes if they are about the case, if the case is over, like in a not guilty in a murder case or a criminal case. If you want to get a big laugh from the jurors, when they ask the question, you say, well, I think I need a sidebar on that. This is how frustrated they are by the sidebar conferences and the objections, that they think that's funny because you're driving them crazy with your objections and in particular with those sidebar conferences. So it annoys jurors that what they're watching is constantly interrupted and slowed down, and that obviously a bunch of information is likely being kept from them. It does not mean, though, that you shouldn't object. It certainly does not mean that. It means you should pick your battles. Because jurors expect and accept some objections. But you got to think strategically and tactically. Objections, for example, cause jurors to pay special attention. Naturally, if you object and the objection is overruled, they're going to pay more attention to what comes after that. You should be aware that there's no, as they say, unringing the bell. So once something gets out there, the more prejudicial it is, the more impossible it is to unring the bell. A very, very disciplined jury for some issues can be instructed to ignore something that they've heard. But usually it's very difficult or impossible to unring the bell. You really need to be confident and professional and successful in your objections. And then if you do that, if you're confident and professional and successful in your objections, then you gain influence with the jury, naturally. They'll pay more attention, for example, to what you say in your closing argument. And professional means respect for everybody else in the case, from the little things to the big things. Treating people with respect, not rolling your eyes when you lose on the objections, acting like a professional. And winning most of your objections helps a lot too. These are the things that cause jurors to credit what you say and to pay attention to what you say. So there are a couple of challenges to objections. For new lawyers, objections can be very difficult. So there are a number of things to worry about. For example, timing. The timing of objections is, it's been analogized to a video game. You have to think quick, and you got to get your objection in there at the right time, not too early and not too late. And this is something we'll work on tonight, but it is an indispensable part of projecting professionalism in your objections. You should, when you're presenting evidence, you should be planning on how to meet the objections that might possibly arise. For everything you present, you should be brainstorming, and it's hard in the beginning. It's hard to put yourself into the place of your opponent, who in the beginning will almost inevitably be more experienced. It's hard to think about what the objections will be and to strategize about that, but it's very important. So if there's a big experience differential, if there's an experience differential between the lawyers that favors you, then that affects strategy. What do I mean by experience differential? So if I were a lawyer and I was trying a case against Mark, there's a big experience differential. I'm much more experienced with him. I happen to wish I was much younger like him, but it can't be. So when I'm planning when to raise difficult evidentiary issues, you know, this is a rough business and there are big consequences for your clients. So if I've got a difficult evidentiary issue that I doubt that he can anticipate and that's going to be particularly difficult if he has no advance notice, then I'm not going to raise it early. Or at least that militates against raising it early in my strategy determination. If the opposite is true, if I'm very inexperienced and he's very experienced, then I'm going to raise it early. Because it's hard enough for me to deal with these issues when I'm inexperienced, that I want all the advance notice I can. You know, these evidence is so difficult for me to deal with it right at the last minute like that makes it all the more difficult. And if I'm not experienced, it's a disadvantage for me. I want to raise it early. I want to raise it early, for example, with a motion in limine. A motion in limine, it means something in some fancy Latin or Greek, I'm sure it must be Latin. It means something like at the doorstep. But what it really means is a motion in limine to keep something out, or a motion in limine to admit something, or to get advance approval to admit something, or to admit it for a limited purpose, or to exclude it except for limited purposes. You're basically seeking an evidentiary ruling in advance. And it can be written and it can be oral. So you need another of the challenges of objections. This is really almost as interesting a video game, the subjecting, as, I'm sorry to say, my kid's favorite, my male children's favorite video game, COD. Do you know what COD is? Oh, bad. It's a fight. I have to keep them away from Call of Duty. So these objections, you got to make them quick, and you got to think through these enormously complicated evidentiary concepts quickly. So in an ideal world, I'd recommend making objections based on multiple grounds in descending order of strength, with just a word as to each reason. I'll get into that a little more later. But that's another part of the challenge, is you've got to instantly object on time and state a basis, if you're going to state the basis in your objection, that's correct, and probably on multiple grounds. If you're really sure, then absolutely go with that single ground, but it's a little bit challenging. It's a little bit risky to say just one ground. That's not exactly what the wonderful author of our textbook recommends, but that would be my take on it. Not that much different than what he's saying. You can't be intimidated by the judge on objections. And we see this with law students and new lawyers all the time. It's not, I've said this before, I'll say it again. It is not your job to be friends with the judge. It really is not. So the judge's natural questions, first of all, they're probably not even intended in an unfriendly way, but vigorous questioning by the judge is often a good sign. And you should not back off on an argument say on evidence, on an objection, unless you think it's a good idea to back off of. You should be able to stand your ground, or maybe to transition to another ground that you're going to argue because the first one doesn't seem to be successful. But you can't be intimidated by the judge. You should be respectful. You should be professional. You really want to be high-level professionals, but you cannot let yourself be intimidated by the judge on objections or anything else. You should not use speaking objections in front of the jury. Actually, it's a problem, a significant problem, and it makes you look like a total amateur. And the speaking objection is, now I think I'm staying on camera, I took a look there. So, objection, judge, that's not an admission of a party opponent. That witness is not a party. This is really, you shouldn't let it in, judge. That's totally inappropriate, and it brands you as an amateur to the judge. The moment you do that in front of the jury, whatever the judge's reaction, which hopefully is temperate and nice and professional as well, the judges think, oh boy, this lawyer doesn't know what they're doing. And so we want to avoid that. No speaking objections in front of the jury. Excuse me. Excuse me. So your objections in front of the jury, as the testimony, should be either objection, one word, or maybe 1 to 3 words, literally, on the basis, or maybe just objection. There are disadvantages to just objection, but I'll talk about those in a little bit. Motions in limine are particularly good for major major evidentiary issues, or time-consuming evidentiary issues, or inflammatory issues. Like when your client's on trial for aggravated rape, and they want to put in a course of conduct evidence that your client committed 6 other rapes. And lastly, for motions in limine, and perhaps I'm not covering all the possible situations, would be for when that experience differential disfavors you. So that's when you want to raise an issue and figure it out, because you have such a huge disadvantage versus that incredibly experienced lawyer that you need the time to think about how to handle this stuff. And if you look on the website, you'll see that there are 2 packets. There are actually 2 versions in 2 different file types of 2 sets of motions in limine. One from a murder case and one from a sexually dangerous person commitment proceeding, which is a civil case, but which can result in your commitment for life. And you'll see in the murder case, the lawyers filed what amount to mostly boilerplate motions, but a good set of boilerplate motions. And you'll see in the sexually dangerous person case, it's not boilerplate really, or it's not made to look like boilerplate. It's customized a lot, and there's a very nice I think it's one long motion in limine, and it's much better. And you'll see I've put on the website my lecture notes on motions in limine, but it's not worth digressing to that degree. But my lecture notes are on the website. Limiting instructions are very important. So in evidence and objections, good lawyers, really good lawyers, use limiting instructions and anticipate when there's a need for limiting instructions. And it's a good technique for getting something in that you might not otherwise get in. And it's a good technique as a backup. You know, you can't get everything in, so you say, okay, Your Honor, if you're going to rule that way, and I wish you wouldn't, but I'd ask you to admit it for the limited purpose of blank. And then the court, the judge, maybe at the time the evidence comes in, or maybe in the closing final instructions, gives the limiting instructions. Folks, this evidence of the 6 other alleged rapes that the defendant allegedly committed is offered for the limited purpose of his state of mind. Now, that's not a good example to show the usefulness of a limiting instruction, because it doesn't sound like it's going to work. But for less inflammatory evidence, it can be very useful, and it's the sign of a lawyer that knows what they're doing. Continuing objections, if you object to the admission of some testimony, and it's basically going to be repeated for a significant length of time, then you perhaps want to ask for a continuing objection so you're not constantly jumping up and down and basically kind of annoying the jury. So the timing of objections, this is something you really kind of have to pick up, and we'll work on that, I hope, tonight. But the timing is so tricky that lawyers, even lawyers that try lots of cases, for good reason, are often rusty at the beginning of a trial. So you'll see lawyers at the beginning of the trial objecting late. And it's probably, in my opinion, because this is something that requires a certain kind of mental looseness to be able to object in a timely fashion. It's a weird sort of thing when you're objecting, because you are objecting often before you know why. So sometimes you'll be objecting and even end up withdrawing your objection when you're asked for the basis. So if the question is improper or calls for inadmissible evidence, the objection should be after the question but before the answer. So you've really, I've never timed it, but in the era of smartphones and everything, I probably should try it. But the amount of time you have to make that timely objection between question and answer, it's got to be often less than a second. So that objection, if you have a truly time-accurate transcript, which we don't really have those usually, but they're pretty good. If you were watching that scrolling transcript in your mind, the objection would be, it would be perfect. After the question mark on the question, objection, and then the answer. If the answer itself is improper, and you didn't have any advance notice from the question that the answer would be improper, then you should interrupt the answer as soon as it's reasonably apparent to you that the answer is improper. Objection. And if if that's the situation, there's got to be a part of the answer that you know is improper. You should be moving to strike that improper part of the answer. Objection. Your Honor, I move to strike everything after the traffic signal was red. And you get a ruling from the judge. It can matter. And maybe it's obvious why it can matter. But for example, for a directed verdict analysis or a required finding of not guilty analysis, evidence that you fail to clean up and strike can end up costing you really the trial. So you've got to make sure that transcript is cleaned up. You've got to have in mind that scrolling transcript, and you've got to be moving to strike things that are improper in the answer. As to exhibits that shouldn't be coming into evidence, shouldn't be admitted into evidence, you need to object before the exhibits are admitted into evidence. So before they put the sticker on, and certainly before the exhibit, to use some legalese, is published to the jury or shown to the jury. When you this courtroom is more of an appellate courtroom, but in a trial, so in the modern courtrooms, and we're not going to do the mock trials in a modern courtroom. We're going to do them in old-fashioned courtrooms, pretty similar to this one actually. But in the modern courtrooms, the judge is not quite as high elevation-wise as in this courtroom. And the judge is more accessible. There are many, many improvements in the modern courtrooms. I work right now in a modern courtroom. And it's much easier to see what's going on with the judge. And many judges, for reasons that are probably very practical, when they see something that's fishy or likely objectionable, they look to the other side. It's not necessarily a hint or anything like that. It's more like I should be looking at this person so that I can catch the objection. That's one of the reasons, at least here, we stand when we object. Because these trials can go on for hours and days and weeks and months. And so, like the Pavlovian dogs, when the judge sees you stand, she's paying a little extra attention and getting ready to process mentally that objection. But if you watch the judge, sometimes the judge will look to you, not saying, will you please object, really, but just expecting an objection to something that's dicey on behalf of your opponent. So let's talk a bit about on appeal. So evidence law is so difficult that it's really very unusual, well, at least unusual for cases to get reversed because of the judge getting it wrong on an objection. Not unheard of, not incredibly rare, but it is unusual. Judge Young, who teaches at this law school, and is certainly my intellectual superior, I can't remember the number he says, but he says something like, and I must be wrong on the number, but his basic point I do remember. He says something like a good judge, a judge who's good on evidence, gets 75% of their rulings correct. And if I have it wrong, the 75%, if I have it wrong, I'm overestimating it. That I'm sure of. So it's either 75% or lower. That's how difficult this stuff is. So it wouldn't make sense, or at least this is a justification, for not reversing every case where there's evidentiary errors, because they often are. So a general objection, so in my opinion, you're often going to end up making a general objection, which is just objection, nothing else. Sometimes, well, often, I'm going to suggest, it's because you don't know what your real objection is. You have so little time to process the information that you just jump up. So you're over here, paying close attention, losing your mind inside, but looking cool and collected. And your opponent asks a question, objection. And right here, you don't even know why you're going to object half the time. And oftentimes, even particularly maybe for experienced lawyers, it's because it doesn't sound right. But that general objection with nothing else is only going to preserve a relevance objection. So that's a weak objection, a relevance objection by itself. So you should be thinking, and you undoubtedly will be thinking hard as you make that objection and the judge reacts. And in that, you could get a couple of seconds out of that. A couple of seconds to think about it. And that can be a surprisingly long period of time. And that can be a very useful time in which you can figure out what is the basis for your objection. Oftentimes the judge will rule without any further anything, just because these trials can take forever and it makes sense to just rule with just a general objection. So in terms of protecting the record, so you've got to be timely, and your objection can be overruled because it's not timely. Now, perhaps the judge will take some pity on you, particularly at the beginning of the trial, but that alone can cause, or can be a reason to overrule your objection. It should be as specific and correct as possible. You should move to strike whenever that's called for, so that it's not, so that this, I'm going to grant myself leave to use this naughty word, so the record isn't full of extraneous information that hurts you. You should be moving to strike when necessary. You should be asking for limiting or curative instructions. A curative instruction is basically the same thing as a limiting instruction. Perhaps you should be moving for a mistrial. I'm not sure that does a lot of good often, but it might make the appellate lawyer's job a little bit easier if the people on the ground during the trial, or at least one side, thought that a mistrial was necessary in order for that party to have a fair trial. If you've got a piece of evidence, if you're offering that book and it gets excluded, and you don't get it marked for ID, you've done your client no good in terms of preserving the objection to the admission of this book. It's a scrolling transcript supplemented by things that are marked for ID or admitted as exhibits. And you're going to have a hard time expanding the record on appeal if something hasn't been marked for ID or admitted as an exhibit. So if it's excluded, you're going to have, judge, may that be marked for ID with the next letter in sequence, or C for ID, which is rarely going to be refused, because what does the judge care if something is marked for ID? It's different, of course, with things that are admitted as exhibits. You should, you got to think this through. So you're trying to offer some evidence. You should be making offers of proof. It's an unavoidable piece of legal jargon. In offers of proof, strictly speaking, an offer of proof is, judge, I offer to prove that this witness, if you let her, is going to say that the traffic signal was green. And that's a good offer of proof. But offers of proof, in a broader sense, can be made in many ways. Judge, I offer, Judge, I'd ask that this statement given to the police right after the car accident, I'd ask that this be marked D for ID. It contains an offer of proof by me as to what the witness will say. Or I offer this affidavit, or I offer this, these 3 pages from the transcript to show what I'm trying to prove here, and I object to its exclusion. But you've got to have that scrolling transcript supplemented by things that are marked for ID or admitted as exhibits, so that everything is really clear on appeal. On appeal, what you wanted to do has to be crystal clear. So it should be crystal clear to the appellate judges what it is that was kept out over your objection. Now, if you object and the objection is overruled, then that's no problem if you're the objecting party, because then what you're objecting to, and that's what's killing your client, is all over the transcript. You should always make sure to get a definitive ruling, and this applies to motions eliminate. Often, the judge will say on the ruling on a motion eliminate at the beginning of the trial or before trial. In some courts, they have a lot of resources. The judge will defer a ruling. It does not mean that it was a mistake to bring the motion to eliminate at all, because you've alerted everybody, you've alerted the judge, you've educated the judge, and the judge will be thinking about it a lot. But oftentimes, the judge will avoid a ruling right away. If it's so complicated that you bring a motion to eliminate, then chances are the judge is a bit unsure as well. Well, not chances are, but often the judge is unsure as well and wants to think about it. But it's not a waste of time. Make sure you get a definitive ruling, even if the judge initially does not want to rule. In some jurisdictions, not in federal court, but basically, in some jurisdictions, not only do you have to object when the judge says before the trial, at the beginning of the trial, or even during the trial, no, I'm not going to let that in. Not only in some jurisdictions, including to some degree Massachusetts, you have to object again at the time. Well, it's a better example is when the evidence is admitted over the objection. All right. If the judge says pre-trial or at the beginning of the trial or during the trial on a motion to eliminate, says, I know you object, I'm going to let that in. In some jurisdictions, that will not preserve your objection. So it's your job as a trial lawyer to do that thing you don't want to do, be an appellate lawyer as well, to make every objection crystal clear. So most of the time, if the judge gives a definitive ruling, no matter when, that preserves your objection. But you have to be all over this. So you have to object, you have to assume the worst and re-object when something is coming in, or make it at least crystal clear, close to the time something is coming in, that you object. So when that statement of your client saying, I did commit those 7 rapes, is coming in, you got to object pre-trial, during the motion to eliminate, you got to object when it comes in. Maybe you want to say, may I have a continuing objection to all of this stuff that's killing me. You don't say killing me, but that's what you're really saying to the judge. The requirements of evidence law, really the law of evidence, the substantive law of evidence, is really divided into 3 categories. So evidence must be relevant, it must be directed at a matter of consequence, and it must be probative. So a relevance objection is a weak objection because what's relevant isn't necessarily very prejudicial to you. So that's perhaps the weakest form of an objection. So evidence also has to be reliable. So that's the basis for much, but not all, but much of the rules regarding hearsay purposes and exceptions. So we generally do not allow second-hand or third-hand or hearsay sources of information because we're usually concerned about reliability. That's not exclusively the concern behind the rules against hearsay, but that's a huge part of it. And the same is true of the rules of competency, like lay and expert opinions, the way we question witnesses on direct and cross-examination, and the authentication and the identification of exhibits. The final major category is that evidence needs to be right. So there we're talking about fairness, efficiency, and policy. And we're talking about probative value versus prejudicial value. We decide to keep out some kinds of character evidence. But some kinds of character evidence we admit. And we have rules about habit in sexual assault cases and privilege. So these are oftentimes policy decisions about things that might be relevant and might even be very reliable, but we decide not to admit them. For example, rape shield laws. So the problems you see in evidence with objections with new lawyers are the following things. So basics. Can you do it in a timely way? If experienced lawyers have difficulty at the beginning of trials making timely objections, then that suggests that this is a significant challenge for you. And not just standing up and talking to the judge like it's your living room. I object or objection. If you object, those have got to be the first words out of your mouth. It's a Pavlovian dog signal to the judge. It's an immediate signal. I'm assuming we have a jury in the room. But even if there's no jury in the room, those are your first words. Objection or I object. If needed, a very basic, very, very short statement of the basis of the objection. So that's the next part of it. No speaking objections, that's another problem. And failing to, for lack of a better term, to force the judge into giving a definitive ruling. Maybe an additional level of skill beyond that is when something is excluded in whatever form, failing to make an offer of proof. That scrolling transcript has got to be crystal clear on appeal, or you have made the appellate lawyer's job that much more difficult, and you haven't done your job as a trial lawyer. And the last weakness on objections is the lack of substantive knowledge of evidence. And this is an enormously complicated area that lawyers with decades of experience don't